CCPA versus CPRA, what are their differences? The California Consumer Privacy Act, CCPA, was signed into law in 2018 and went into effect in 2020. It gives Californians new rights over their personal data, including the right to know what data is being collected about them, the right to delete that data, and the right to opt out of the sale of their data. The California Privacy Rights Act, CPRA, was passed by voters in 2020 and will go into effect in 2023. The CPRA expands the CCPA by giving Californians additional rights, such as the right to correct inaccurate data, the right to know about automated decision-making, and the right to limit the use of their sensitive personal information. The CPRA also creates a new state agency, the California Privacy Protection Agency, CPPA, to enforce the law. The CPPA will have the power to investigate complaints, issue fines, and order businesses to take corrective action. The CCPA and CPRA are significant pieces of legislation that will have a major impact on how businesses collect and use personal data in California. Businesses that fail to comply with the law could face significant fines and penalties. Here are some of the key differences between the CCPA and CPRA. The CPRA expands the definition of personal information to include sensitive personal information, such as race, ethnicity, religious beliefs, and sexual orientation. The CPRA gives Californians new rights, such as the right to correct inaccurate data, the right to know about automated decision-making, and the right to limit the use of their sensitive personal information. The CPRA creates a new state agency, the California Privacy Protection Agency, CPPA, to enforce the law. The CCPA and CPRA are a major step forward for privacy in California. These laws will give Californians more control over their personal data and make it more difficult for businesses to collect and use that data without their consent. In addition to the above, here are some other key changes that the CPRA makes to the CCPA. The CPRA increases the threshold for businesses that must comply with the law from $25 million in annual revenue to $50 million in annual revenue. The CPRA expands the definition of sale to include the sharing of personal information for advertising purposes. The CPRA requires businesses to provide consumers with more information about how their personal information is being collected and used. The CPRA gives consumers the right to sue businesses that violate the law. The CPRA is a significant update to the CCPA and will make it more difficult for businesses to collect and use personal information without the consent of consumers. Businesses that fail to comply with the CPRA could face significant fines and penalties. Thank you. If you liked our video, please like, subscribe and share.